The next important report on providing free legal aid, how do we secure it in India, came from Experts Committee report on procedural justice to the people. This was established by the central government in 1973 under the chairmanship of Justice Chris Nyaya. And the committee has given a detailed report and recommendations on how this legal aid should be carried out in India, giving the stature of Justice Chris Nyaya and his commitment towards the poor people. This expert committee report has a very significant role played in future of how this legal aid is going to be implemented in India. Now, the most important observation made by this committee is that legal aid is not a charity. It is a right, it is a matter of right. So, therefore, the entire jurisprudence that is developed by the other committees, that legal aid as a charity by the state, therefore, it depends on the state financial ability, is no more acceptable. So, he says that the providing legal aid is being a constitutional mandate cannot be a charity. It is a matter of right for the people to ask free legal aid. Then, therefore, the state funding and statutory incorporation of the legal aid should be necessary. The moment it becomes a right, the state should have a specific allocation of budget for providing legal aid. The state should also provide for the creation of national legal aid body for free legal services. It should be statutorily free from official or party pressure. So, the committee is very clear in their mind that a national body that is established should be clear from any political pressures. It should be an independent body. The national authority should be responsible to the parliament and the public through periodical reports and audits and annual reports to show how the legal aid is working. And it also looked at developing of the network between legal aid groups like bar association, law schools, community organizations, organization of local governments, and ad hoc panels of the lawyers who are providing free legal aid. And it committee also not only looked at providing free legal aid, it also spends a considerable time and says that the reforming of the law is another important aspect for providing free legal aid. It says that you need to reform the law and procedures to make the courts, prisons, bar council, bench, police, public servants more responsive to the citizens. That means the laws should be simplified, procedures need to be simplified, make all these enforcement mechanism people's friendly. And it also talks about modifying the curricula of legal education. It says you change your curriculum and create rapid and inexpensive dispute settlement mechanisms. That means the law school should also propagate how to provide justice at a much lower cost. And it talks about creating local legal aid cells, and they say that each local legal aid cell should have a representatives of potential recipients of service. This is the first time that the committee is asking that even the public should be part of a legal aid committee, because they are being the recipients, they should be part of the committee, so that we know how the legal aid should provide to the people. And then the representatives of those who provide the legal aid, for example, the lawyers, bench, etc., and the representatives of the relevant mass organizations. These are the members of the local legal aid cells. Then it also says that the students working in the legal aid work should also be included, and they should be allowed to represent in the court under the supervision of the practicing lawyers or the law teachers. And the expert committee, in addition to talking about free legal aid, it also talks about speedy trial. So, providing legal aid would not be sufficient when the trial takes too long. Therefore, it says that for providing speedy trial, a considerable amount of time should be spent in selection of the candidates for the judicial and police posts. So, while you are selecting the judicial and police post, you should look at their social sympathies, where their priorities lies, that should be considered. And it also talks about the mobile courts for trying minor offences on the spot rather than bringing them to the court. Provisions regarding to the summary trials would also help in disposing the petty cases very quickly and cheaply. It also talks about reduce the legal formalities to the minimum. So, all those procedural formalities should be reduced to the minimum. Pleadings and settlements of the dispute should be without a detailed litigative stages. And it also talks about statutory method by which the police would look into small complaints without a detailed process of investigation. That means need to bring a new law to reduce this procedural requirement of police investigation. And it suggests that the Nyaya Panchayats must be entrusted with wide powers to provide low cost justice. The concept of legal aid is sufficiently wide to include legal advice. Therefore, you should not confine only to providing legal representation. The another aspect looked at by the experts committee is reducing the cost. What it talks about is exempt the assisted person from all expenditure on process fees, witness, etc. That means once a person is entitled for legal aid, he should be done away with all these processing fees. And also it suggested again that use the students to cut the cost. And same like earlier commissions, it also talks about means test, prima facie test and a reasonable test, it talks about it. Further, it also says that the social purpose should be served for filing a suit or defending it should be considered as one of the tests to decide whether the claimant is required a free legal aid or not. And it also says that the legal aid should not be tendered to artificial persons except in case of trade unions and cooperative society. That means for the companies, partnerships and all, generally it should not be provided. It also suggests amendments to the Order 33 and Order 44 of the Civil Procedure Code to enable the court to assign a pleader at the expenses of the state to a person suing or defending as an indigent person. And also it says when both the parties obtain a legal aid, it is always better rather than sending this case to the court to send it to the arbitration. Unless the issues in this case is too complicated and need to be decided by the court. And if any one of the party is not agreeing for the arbitration, then the committee suggests that withdraw the free legal aid for that party. And further it says the existing Order 44 of the Code of Civil Procedure Code talks about the pauper appeals should be amended to provide that once the applicant is allowed to sue as a pauper, no further inquiry as to pauperism is necessary unless the appellate court sees cause for such an inquiry. That means once a person is already declared as a pauper and his case was already tried in the court by providing free legal aid, when that person appeals, automatically the legal aid should continue unless the court thinks that there is some change of circumstance. And then it comes to the criminal cases, again the court says that even in criminal cases you need to provide free legal aid, but you need to apply means tests. But this means test should not be applied in cases where the penalty is either death or imprisonment for life. That means apart from offences which deal with death or imprisonment, in all other civil criminal cases the means test could be looked at. An applicant should not be required to demonstrate any prima facie case for his innocence in case of criminal, whereas in civil cases the prima facie test is compulsory, but when it comes to the criminal cases the prima facie case is not necessary. The moment a case was registered against the accused for committing an offence, that is sufficient. If he cannot afford for a lawyer, a free legal aid should be provided. Legal aid should be denied to the habitual offenders and generally to those who are involved in election, defamation, adultery and in private claims. That means these are the category of offences where usually the legal aid should not be provided. Regular legal aid and advice of inmates of jail should be conducted in jails. Bail policy should be liberalized. So, the expert committee also now talking about the prisons. In the prisons, you provide legal aid on a regular basis. Further, the bail procedure should be liberalized, particularly avoid monetary surety as a compulsory condition for releasing on bail, because people who are not afford to provide monetary sureties would be difficult for them to secure the bail. Then the category of the bail offences in the criminal procedure code should be enlarged. The right of a person to access a lawyer at any stage of police investigation should be legislatively provided. That means statutory recognition of free legal service even at the stage of police investigation should be recognized. The committee also talks about legal aid committees should be given powers to visit prisons periodically to ensure the proper enforcement of prison manuals. And it also talks about research. They should appoint or establish a research and development cell. Periodical reports must be sent to the parliament and to the state legislatures. It talks about legal literacy. It says that the obligation of the state to provide legal literacy through radios, televisions, films to make the people aware about their rights. It also talks about a statutory provision to ensure minimum hours of free legal aid work to all lawyers, so that they would be able to provide free legal aid to the people. So, on the whole, the committee has given very comprehensive report on how this legal aid should be provided and given to the people at large.